should do that as well. All right, so we're going to continue on today with our discussion that we started on Tuesday on the courts. You'll remember that we spent really the entire class meeting after the quiz talking about a select group of cases. As I said, this is not a randomly generated group of cases. I selected these cases deliberately to make the point, but which is really still to be hammered home, but we kind of got to that at the end of the class meeting. We spent a little bit of time, not a whole lot, talking about each of these cases. I reminded you that some of them you should be familiar with because we've dealt with them previously. There's a couple on the list, certainly, that we're going to be dealing with next week when we take up the topic on civil rights. But really the broad overarching point that I was trying to make and that we're going to develop in today's class meeting is that all of these cases, in addition to the fact, as we said last time, in addition to the fact that they were very controversial at the time that the court handed down their decision, generated a lot of public debate, a lot of discussion, a lot of editorial articles written, a lot of commentary, a lot, et cetera. For some of these cases on this list, that controversy lingered for decades. And in fact, even down to today, as I was telling you, I think specifically, I tried to make that point with the Griswold case, right? It's a case that pops up now and then in the debate over specific issues as they are related to the right to privacy. So that was one aspect that we talked about last time, but I think the broader point, the broader takeaway is that what all of these cases have in common is that at least part of the criticism that was leveled at the court in response to its decision in these cases is that it was engaging in judicial policymaking. That for many critics, this is not a proper role for the courts. It's not a proper role specifically for the United States Supreme Court, for the judicial branch of government to make policy decisions. The critics argue that that is really the purview of the legislative and executive branches, precisely because those are the elected branches of government. That, people elect members of Congress, they elect the president, they elect their state legislators, they elect their governors, they elect their local city councils or their school boards or whatever the decision-making body is to make these decisions. And it's really not proper for 9 justices, unelected and really appointed for life terms, right? The Constitution says that federal judges are appointed for periods of good behavior. But what that means for all practical purposes is that they're there until either they die, like Justice Scalia or Justice Ginsburg, or they retire. Okay? As long as they don't get into any trouble, criminal trouble or whatever, where they might be impeached, then they're there for life terms. So that's the criticism that many people have. And what I told you right at the end of the class meeting was that, as a political scientist, I'm going to tell you that there are decisions of courts that do constitute policymaking. Not all of the decisions of courts. Now, let me talk specifically about the Supreme Court here. I'm going to focus. A lot of what we're going to say in today's class meeting apply to the courts generally, but it's easier for me if I just focus on the Supreme Court. So all of the decisions of the Supreme Court do not amount to examples of policymaking. Some do and some don't. So where we left it last time was saying that as political scientists, we need a more objective set of criteria, because when you think about each of these cases that we talked about last time or others that we might put on this list, when the critics have leveled their charges of judicial policymaking in the courts, it's generally the people that think that the court got it wrong, right? So, for example, in the school prayer cases or in the religious exercises in public school cases, I'm talking about these 3 that we talked about last time: the Engel versus Vitale School District in Abbey Township versus Shemp, and Murray versus Kirtland. Those are three, certainly not the only three decisions that the Supreme Court has made dealing with religious exercise of religious practices in public elementary and secondary schools. But these were three very important early cases that the Supreme Court decided back in the 1960s. And the critics who say that the court is acting improperly, that it's making policy when it should just be adjudicating case law, is generally going to be the people who thought that we should have prayer in the public schools, who supported prayer in the public schools. And as I said last time, the people who thought that the court got it right were more likely to say, no, the court's not making policy. They're just upholding the Constitution. They're upholding specifically the First Amendment, the Establishment Clause of the Constitution. Okay? And that's the pattern that we see with all of these cases. So again, we have to have a set of objective criteria. We're going to get to that in a matter of moments. Before I do, though, I want to just suggest to you that, because I think I hinted at this in the last class session, that presidents or presidential candidates oftentimes during the course of their campaigns or during the course of their presidency will have one reason or another to attack the courts. For example, and this isn't going to be up here long enough for you to transcribe, or I'm not even going to read them to you. I'm just going to put them up here as examples. Here is an example. I don't know if you can remember back during Trump's presidency when he got into it with Chief Justice John Roberts about Trump had made some kind of comment about Trump judges and Obama judges, and uncharacteristically the Chief Justice snapped back in a public way that there are no Obama judges, there are no Trump judges. But what that was a little bit more of a sort of personalized exchange between the two. But what it really sort of is an extension of this question about the role of the courts. Okay, you can see here's a passage from Donald Trump's first Attorney General, Jeff Sessions, before he resigned his office. And he gets more to the point that we're talking about because he actually uses that term activist. And we're going to make the distinction in today's class meeting between judicial activism and judicial restraint. But here you see Jeff Sessions, by anyone's estimation, a conservative Republican, accusing the court of, if he does not use the term policymaking in this particular blurb, when he uses the term activist, the people he's really directing that criticism to, the audience that he's really directing that to, is going click, 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 click. Oh yeah, he's talking about the courts making policy, right? And then here's one from former President Obama, where he sort of makes the point that whereas in the past it was pretty clear that activist judges were politically liberal, it appears now when he gave this comment, it's been a decade ago, but when he made this comment, it appeared to him that the activism was no longer with political liberals, it was with political conservatives. Right? And then here's one from going back to Franklin Roosevelt, where he makes some comments about the court overstepping its authority. Here's Theodore Roosevelt. The first one was Franklin Roosevelt. This one here at the top is Theodore Roosevelt. Another one from Theodore Roosevelt here. Here's one from Abraham Lincoln, right, where he's talking about the courts acting improperly. Andrew Jackson. And then the last one I have on the list here, just to trace it back as far as I possibly could, give you some examples. Thomas Jefferson may be the first example that we have of a president who's sort of lambasting the court for what he perceives as the court stepping outside of its proper constitutional authority. Okay, so it's really not a new debate. It's been with us from the very beginning. What is the proper role of the courts? And we're going to get into that in a little bit here. We're going to talk, for example, about the arguments made by Alexander Hamilton in Federalist number 78. Okay, let me just sort of set up this discussion and sort of show you where we're going with this. We, just started by asserting that as political scientists, objective as we are, or at least we attempt to be, there's no denying that the court, at least from time to time, engages in policymaking. Okay? Now, it's been a while back. In fact, we have to go back to the very beginning of the semester when we had a little bit of introduction in this course. We do it a little bit more thoroughly in the 2306 course, but we had a little bit of introduction to the idea of policymaking in our first week of the semester. Okay? And so I don't know if you remember the use of the term agenda setting and all of that maybe by the authors of your textbook, but even if you don't remember that, it's not that complicated of an idea. When we talk about the role of the courts as policymakers, one of the things that we want to focus on is what we call the agenda setting stage of the process. Okay? How problems get, whether we're talking about the Congress or the president or a bureaucratic agency or the Supreme Court of the United States or a state legislature or a city council or whatever the governmental institution is, their agenda is the set of problems that they are addressing, right? It's the set of problems or issues that they're taking up for consideration, for reflection, and possibly a policy response. In the context that we're using the term agenda, that's what we mean. The agenda setting stage of the policymaking process is really the beginning of the process, and what we're going to refer to as the government's agenda or a government's institution's agenda is simply the set of problems that that institution is currently addressing and possibly will produce a policy response. Does that ring a bell? It's been 13 weeks ago, right? It was a little bit of a treatment at the very beginning of the semester, okay? So one of the things that we can say that is different about the courts, and specifically the United States Supreme Court, as contrasted with the other branches of government, as contrasted with Congress or the president or even a bureaucratic agency, is that unlike those institutions, the Supreme Court cannot actively go out and identify social problems that it wants to address. Okay? Congress can do that. Members of Congress can do that. They can say, okay, we want to address the economic downturn that is the result of the coronavirus pandemic, right? And they can draft legislation that to provide economic stimulus checks or whatever else might be in that American Rescue Plan, as it was called, right? The president can do the same. Bureaucratic agencies can go out and identify problems. In fact, that's part of their mission, as you just learned, the most recent topic that we've dealt with on the syllabus on bureaucracies, that bureaucracies engage in policymaking, and they can go out and identify problems and place them on the agenda, right? But the courts can't do that. Specifically, the United States Supreme Court can't do that. Instead, they are passive actors in the agenda setting stage. In other words, they have to wait for the problems to come to them. And those problems specifically come to the court in the form of what? In the form of litigation, right? Where you have some sort of legal action, a lawsuit, that usually the overwhelming majority of the cases, it's going to be an instance where you've had an initial decision by a trial court and then maybe 2 or 3 additional appellate courts that have rendered decisions, and then it gets up to the United States Supreme Court. Okay, so that's the first initial point I want to make, is that unlike the other institutions of government, in the policymaking process, the courts are passive actors when it comes to agenda setting, because they can't proactively go out and address social problems. Say, this is a problem that we think needs to be addressed. Okay? Now, having said that, okay, there's a very important distinction that you need to be aware of when it comes to the United States Supreme Court. I am now talking specifically about the United States Supreme Court. I've made the distinction here between original jurisdiction and appellate jurisdiction. Now, what we mean when we talk about a court of original jurisdiction, we simply mean that it is the court that hears the case first. Pretty straightforward, right? Court of original jurisdiction is the court that hears the case first. But what may not be just immediately apparent probably would get to it upon a little reflection, is that that means that it is the trial court, okay? And in our legal system, trial courts address questions of fact, and they attempt to reconcile the facts with the existing law. And a very obvious way to illustrate that would be to talk about, say a criminal case, right? Where the police apprehend and arrest a suspect, and the prosecution moves forward, brings charges against the defendant. You have Smith versus the state of Texas, right? Smith is the defendant, right, being accused of a crime. Or I said that backwards. It would be the state of Texas versus Smith, right? The state of Texas is the one that's bringing the action, right? So Smith is the defendant, and it is the role of the trial court, the court system in Texas. The state court system in Texas is pretty complicated, but let's just say we're talking about a state district court. This is a robbery case, for example. What is that court going to do? Well, the prosecution is going to present the facts as they perceive them. The defense is going to mount some kind of defense, maybe present an alternative set of facts, right? And then it's the role of the court, whether we're talking specifically about a judge or whether we're talking about a jury, a trial jury, they're going to sort out the facts, determine which version of the facts they think are most plausible, and then apply the law that is relevant. Okay? So again, courts of original jurisdiction are the first court to hear a case, but it also means that they're functioning as a trial court. And trial courts are generally, with the exception that we're going to talk about here, trial courts are generally presided over by one judge. Appellate courts, on the other hand, don't really address questions of fact. Those are in the record of the trial court. They are addressing questions about the application of the law, right? In other words, they interpret the law and how it was applied. Okay, so appellate courts are dealing with interpretation of law, how the law was applied, was it applied fairly, was it applied consistently, other kinds of questions along those lines. And appellate courts are generally panels of judges, usually an odd number, right? 3, 5, 7, 9, something like that, right? To avoid, as much as possible, avoid ties, right? So you can have a definitive decision. Okay? Now, when we talk about the United States Supreme Court, you can see just by looking at those numbers on the screen that overwhelmingly the function of the United States Supreme Court is to hear cases on appeal, right? 95% of the cases that come before the United States Supreme Court fall under its appellate jurisdiction. Only 5% of the cases that the court hears in any given session is it functioning as a trial court. And I want to say now, and you need to take note of this, either mentally or actually take it down, maybe highlight it, put an asterisk by it or something like that, okay? It is important to understand that when we talk about the Supreme Court of the United States, the original jurisdiction is set by the Constitution. The original jurisdiction of the Supreme Court is set by the Constitution. So here is a brief summary of what the Constitution provides. With respect to the original jurisdiction of the Supreme Court, the court may assert original jurisdiction in all cases affecting ambassadors, other public ministers, and consuls. If, for example, the President of the United States is one of the parties to the litigation, there's a pretty good chance that the Supreme Court is going to assert original jurisdiction. A good example of that would be, for example, back in the 1970s, when Watergate was coming to its pinnacle of, its climax, The whole scandal was, everything was out there. Everybody, the Congress, which was conducting an investigation of the activities of the Nixon White House, became aware that as a result of testimony from a man by the name of Alexander Butterfield, who worked in the Nixon White House, that all conversations in the Oval Office had been recorded. There was audio recordings of every conversation that had existed that had ever occurred in the Oval Office during the Nixon presidency. And so the committee that was investigating the illegal activities of the Nixon White House, understandably, wanted to get their hands on those tapes. But President Nixon refused, claiming executive privilege. And it meant that if Congress was going to get to hear those tapes, going to get access to those tapes, they were going to have to take the president to court. And that they did. In that case, U.S. versus Nixon was heard by the United States Supreme Court. By the way, unanimous decision of the United States Supreme Court that Nixon had to turn over the tapes. And then, of course, I don't want to digress too much on the whole Watergate thing, but then, of course, that's when we learned about that mysterious 18-minute gap on the White House tapes where it was just silence. Okay, anyway, the point is that most of the cases that the Supreme Court's going to hear don't fall under this jurisdiction, they fall under the appellate jurisdiction. And this is pretty broad, okay? The way that this is worded in the Constitution, all other cases arising under the judicial power of the United States. That is a pretty sweeping statement. And it raises the question, certainly did in the beginning, and over time has raised the question, well, what is the scope of the judicial power of the United States? I think what ultimately it has come to mean, what we understand it to mean today, is that the Supreme Court can exercise appellate jurisdiction over any cases or over any case that raises questions of federal law. So even if it's a case that begins in a state court, like let's say it's a murder case, a murder trial, and there's a conviction and a death penalty sentence that's given, and the defense lawyers want to appeal the decision, and it goes up the appeals process, there's a chance that the United States Supreme Court will hear that case, not a big chance, okay, because it may raise questions under the Eighth Amendment, which is, the U.S. Constitution is something that presumably the Supreme Court, that the judicial power of the United States would, apply to. Okay? So that's why we see here, to go back, notice that 95% of the caseload falls under the appellate. It's an appeal. These are appeals, okay? And notice that well over half of those, 65%, almost 2/3 of those, follow the federal route, okay? That is to say, they originate in federal court, and then, you have a trial in the district court, and then up to the Circuit Court of Appeals, and then you may get an appeal that is granted to the United States Supreme Court. But a not insignificant percentage, about 30%, follow the state route, right? So, for example, every session of the Supreme Court, there's going to be a considerable number of cases that come from one of the states, and maybe even Texas, right? For example, maybe there's a case that arises in Texas. Let's see if we can make this case or make this point using a case that we referred to last time, that Lawrence and Garner versus Texas case, right? Remember? If you forgot about what we talked about in the last class meeting with that case, maybe recall, if you've done the week 5 material, what you learned about that Lawrence and Garner case. Anybody remember what that case was about? Just give me the broad issue. Who remembers?
Gay marriage.
Not gay marriage, okay? That's not the specific issue here. You're certainly in the ballpark. This question was about the law of the state of Texas that made consensual sexual relations between same-sex couples a crime. It was what the Texas Sodomy Law. Right? That case originated in Houston, Texas. Right? Harris County Sheriff's deputies arrived at the residence of a gay man, an anonymous tip about a disturbance occurring within a residence, and there they found two gay men engaged in a consensual act of sexual intercourse, and they arrested them because that was illegal under Texas law. Right? They're convicted in a state trial court here, state trial court. We have an appellate court system in Texas, so you kind of go up the ladder, and ultimately it got to the Texas Court of Criminal Appeals, which is essentially the state Supreme Court in Texas for criminal cases. You'll learn about that when you take the Texas government course. We actually have two state Supreme Courts in Texas. Okay? The one that deals with criminal cases is called the Texas Court of Criminal Appeals. So that case, Lawrence and Garner versus Texas, took this route, right? And because it involved a question about the Constitution, and specifically a constitutional right, the right to privacy, it fell, at least according to the United States Supreme Court's view of things, under the judicial power of the United States, and they agreed to hear that case on appeal. Okay? So those are the two possible routes that you can get an appeal go to the United States Supreme Court. Now, what form does that appeal take? Right? The main avenue is what we call the writ of certiorari. Okay? The writ of certiorari, in our legal system, that term W-R-I-T, writ, refers to a court order. We have a number of different types of writs: writs of mandamus, writs of error, writs of habeas corpus, right? This is called a writ of certiorari. That word certiorari means the writ of certiorari, the decision to review, right? And it's important to understand that the United States Supreme Court does not have to issue a writ of certiorari when somebody files an appeal. In fact, it's very unlikely that the court will issue the writ. Okay? Anybody want to take a guess? Who's read ahead, already read the chapter in the textbook on the courts? Nobody? Well, maybe when you read through that chapter in anticipation of the reading quiz next week, this will stick out in your mind because I'm about to tell you. Okay? It depends on the source that you're looking at, but most sources will indicate that the Supreme Court receives anywhere from about 8,000 to 10,000 appeals in a session of the court. In a year, the session of the Supreme Court runs from October to May. So as many as maybe 10,000. So let's say on the conservative side, 8,000. Okay? Of those 8,000, somebody give me a wild guess. How many do you think out of 8,000, how many do you think the court actually agrees to hear?
Doesn't?
No, I'm surprised. Usually when I ask that question, people are saying about 1,000 or something like that. So you guys are at least closer. Okay. Again, it depends on the source that you're looking at, but say 80 to 100. Right. So the odds of getting an appeal of the United States Supreme Court to issue the writ of certiorari in an appeal are not good. Now, the explanation of that may be pretty straightforward, right? The ability of the court obviously cannot review 10,000 cases a year, in addition to cases that might fall under its original jurisdiction, right? So there's only 9 justices, right? So they're going to have to be selective about which cases they hear. That raises a very interesting question, which we're going to get to here very quickly, right? What goes into that decision-making process? What determines whether the Supreme Court will hear Angie's case, but they won't hear Adams, Hisham's, Jacobs, and the rest of your cases, right? What goes into that decision-making process? That's an important question for us to address. And believe me, there's no shortage of scholarship on that question. There are legal scholars, political scientists, law scholars, even historians and others who have, spent their life's work researching and writing about that question. Before we jump to that, though, there is one little technical point I think we need to get to here, and that's the point here about the rule of four. It's worth noting that it only takes 4 justices to agree to issue the writ of certiorari. Why is that significant? The rule of 4 means that it takes 4 justices to agree that the court should review the case, to issue the writ of certiorari. Well, I think that's significant because assuming that the court is fully, has all the members in place, it's a minority, right? 9 justices, so a minority of 4 can make that determination. All right, so I'm going to introduce you to 2 theories here. No shortage, as I said, no shortage of scholarship, no shortage of theories out there to offer as explanations for this very important question. Why does the court decide to hear this case but not these other, cases over here? And the 2 theories that I'm going to introduce you to are merits consciousness and Q theory. I find these 2 particularly interesting. So let's just take them in turn. Merits consciousness, okay? Seems complicated at first, okay? But be patient. Allow yourself to understand this, okay, as I put these points up here. This is the theory that there is a link. You got to think about this theory at the level of an individual justice. That's what we call the judges on the Supreme Court. They're called justices. We got 1 Chief Justice and 8 Associate Justices, right? So you got to think about this at the level of an individual justice. An individual justice on any given case potentially will cast 2 votes. The first question is, do we want to dedicate the limited time and resources of this body to reviewing this case? Are we going to hear this case? That's the first question. So they've got to cast a vote on that, whether to issue the writ of certiorari. Assuming that the court you get at least 4, right? And the court does review the case, the second vote is going to be on how the case itself should be decided. And the merits of the case. That's where the term merits consciousness comes from. So what this theory is saying is that there's a link between those 2 votes, such that a vote in favor of issuing the writ of certiorari on the one hand, and the vote once the court reviews the case to reverse the decision of the lower court, that there's a link between those 2 things. It suggests that somehow if a justice votes to issue the writ of certiorari, it must mean that the lower court got it wrong. And they're reviewing, in the view of that justice, of that individual justice, must think the lower court got it wrong. And therefore, this case needs to be reviewed. Does that make sense? So the other side of the coin then would hold as well, right? That a vote against issuing the writ of certiorari, if a justice votes against issuing the writ of certiorari, that's linked to a likely vote once the court reviews the case to affirm the lower court's decision. The lower court got it right. Again, suggesting that somehow the individual justice perhaps thinks that the lower court got it right, and so therefore no need for the Supreme Court to review this case. what I think is very interesting about this theory is that it at least implies that individual justices may have already determined how a case should be decided before they ever read a written brief or hear an oral argument before the court. Does that seem like a plausible conclusion to reach, that if there's any validity to this theory, might it mean that the individual justices have already made up their mind, at least in many cases? It certainly wouldn't surprise any of us to think that Chief Justice John Roberts or Associate Justice Kavanaugh or Associate Justice Comey or Associate Justice Gorsuch or Thomas or any of the other justices that are currently on the Supreme Court, or at least aware of these cases as they're coming up the pipeline, so to speak, right? They don't, just live in their chambers. They have access to news and information and all sorts of, detail on cases that are making their way up the process. So it seems reasonable to think that they've at least thought about these cases ahead of time. Whether they've made up their minds ahead of time is, of course, going to be a question that's really hard to answer, right? It calls for a political scientist like us to be able to ascertain the operation of Justice Clarence Thomas's mind, or the operation of Chief Justice John Roberts' mind. And of course, we can't do that. But the theory is saying that, well, it's interesting that there appears to be this link between these two potential votes. As a political scientist, I've got to tell you that I've said several times that I think this theory is interesting, but I'm going to be real honest with you. I find it empirically unsatisfying. And what I mean by that is I'm an empirical political scientist. I like to see whether or not whether theories and hypotheses are supported by the real world data. Does the data, do we see this in the data? And so when I say that it's not empirically satisfying, what I mean is that there's just not a whole lot of compelling evidence in the data to support this theory. Because it would suggest perhaps that if the court does decide to review a case, there's a good chance that they're going to overturn the lower court's decision. And that just doesn't seem to hold up. There's lots and lots and lots of cases where the Supreme Court affirms the lower court decision. As with the case that I described to you, the Lawrence and Garner versus Texas case. In that case, the Texas Court of Criminal Appeals had, well, now I'm going to have to correct myself. I think that's probably not a good example. I'd have to go back and look at that. I can't remember what the finding was of the Texas Court of Criminal Appeals. But certainly there are many, many cases where the Supreme Court affirms the lower court's decision. A better theory, just from an empirical standpoint. By the way, when I say it's not empirically satisfying, I'm not saying it's not valid. Okay, those are, I don't know, how much your educational program, how much research design and data analysis is in your future for your degree program. But if you do get some of that in your education, hopefully somewhere along the way, you'll learn why saying that there's weak support empirically for something does not mean that it's not valid. They're not saying the same thing. This could be a valid theory. Okay, so more empirically satisfying, at least for me, is Q theory. So let me introduce you to that one real quick. Q theory contends that the probability that the United States Supreme Court will hear a case on appeal increases as the number of Qs that are present increases. I like to, as an analogy, invite students to think about how weather forecasters operate. You know, when they tell you, has anybody seen the weather forecast for today? Nobody? Let's just say I haven't either. Let's just say it looks like it's kind of getting cloudy. Let's say that they've said there's a 20% chance of rain today. What does that mean when they say a 20% chance of rain? And while you're reflecting on that, let me tell you what it doesn't mean, okay? Because I find that the local weathercasters that you have on the local TV news stations frequently say this wrong. Okay? I'm not a meteorologist. I'm not trying to tell them their business. Okay? I have a feeling that many of them are not meteorologists either, that they went to university and they got a degree in broadcast journalism and somehow they got channeled into being the weatherman or the weatherwoman, right? They may have that little seal. Some of the local weather people still show their seal of approval from the American Meteorological Society. That used to be a big thing a few years ago. You know, Joe Smith has his seal of approval from the American Meteorological Society. And they would show that on the screen right before the weathercast. Like you can trust his weather forecast. I always suspect that just means that they paid their dues, their professional membership. Anyway, they'll say, sometimes I've heard them say that there's a 20% chance, or let's get a bigger percentage chance of rain. They'll say there's a 70% chance of rain today. 70% coverage. That means 70% of the area is going to get rain. And it doesn't mean that. Okay? Again, I'm not a weather person, but I do have a background in probability theory and statistics. And I can tell you that that's not what that means. It's a relative frequency. What it means is that in the past, when the atmospheric conditions existed that they expect to exist today, it rained 70% of the time. You could have a 70% chance of rain and nobody gets rain in the area. You could have a 70% chance of rain and it's a deluge. Or you could have a 70% chance of rain and there's just a few sprinkles. We've all experienced that. Wait, what happened? They said it was a 70% chance of rain today. Where's the rain? Or there's a 20% chance of rain and it's just, you get deluged, right? So think about this Q theory in the way that we talk about the probability of rain, or that we should be talking about the probability of rain. So if, for example, given what I've suggested to you, it really means if the probability of rain today is 70%, how many of you would take an umbrella with you? Because you would think that there's a good chance that you're going to get wet. You may not. You may just have to carry that umbrella around all day and never open it up. But 70% is a pretty high chance of rain, pretty good chance of rain. So you think it's wise to carry an umbrella. Okay, so with that in mind, what are some of the atmospheric conditions? Right? What are some of the cues that might be present in a given case that would indicate a greater or lesser probability that the Supreme Court would review this case on appeal? Okay? The first one, the federal government favors Supreme Court review of the case. Or maybe a high-ranking federal official like the President or the General publicly endorses the Supreme Court reviewing the case. If maybe a highly visible senator or something, right? If the federal government, if, say, the Attorney General of the United States is on public record saying that this case is one that the Supreme Court really ought to review, then that suggests a higher probability that the Supreme Court will review the case. I want to be clear though on what I'm saying, that you understand what I'm saying to you here. I'm not saying that the Supreme Court will review the case because the Attorney General said so. It could very well just mean that if the Attorney General of the United States thinks it's a case of great importance, that he would come out or she would come out and publicly make such a statement, there's a good chance that maybe the justices of the Supreme Court see it the same way. Okay? But this happens. This is not novel. This happens from time to time where maybe the president or the attorney general or somebody comes out and makes that kind of statement, suggesting that, hey, maybe in a few months we'll see that the court will issue that writ of certiorari. Number two, if there are sharply differing or divided opinions expressed by justices on the lower court or between two or more courts in the appeals process. So remember what I told you about appeals courts, right? Appeals courts are panels of judges, 3, 5, 7, 9, whatever the case is. So unanimous decisions of appeals courts are not that common. Usually you're going to have some sort of split decision. Maybe if it's the Texas Court of Criminal Appeals, for example, that has 9 justices, right? So maybe it's a 5-4 decision or a 6-3 decision, something like that, right? Now, again, I know that this is not a law school course, but this is not such an advanced notion that even in this course that students shouldn't be expected to understand this. When an appeals court reaches a decision, we ought to want to know, and people who follow the courts certainly want to know, not only how the court decided the case before it, but why it decided the case the way that it did. And so to that end, by way of explanation, when the courts decide their cases, the appellate courts decide their cases, the justices, there may be one or more opinion that is issued by the court. You're certainly going to have a majority opinion. One of the justices in the group that was in the majority, if it's a 5-4 decision, for example, the 5 that are in the majority, one of those justices is going to write out the reasoning that led those 5 justices to that conclusion. And maybe one or more of the other 5 will join them in that opinion. They sign on to the opinion. Oh, that's good, Neil. Let me sign on to that. You may have what's called a concurring opinion. In that group of 5 or 6 or whatever the majority is, maybe you have 3 justices who reached the decision for one set of reasons, and you had another 2 that reached the same decision but for different reasons. So they write what are called concurring opinions. We agree with the majority, but not for the reasons that the majority laid out. The authors of your textbook are going to tell you about controlling opinions. I'm going to avoid that just in the interest of time and leave that to the authors of your textbook, something called a controlling opinion. Okay? I think we should at least briefly talk about dissenting opinions, though. So if it's a 5-4 split, you have the 5 in the majority and the 4 who were not in the majority. And one or more of those justices may want to write out their reasoning for why they couldn't agree with the majority. And sometimes dissenting opinions are very, very important. Sometimes dissenting opinions in one case may become the basis of a majority opinion in another case somewhere down the road. For example, the dissenting opinion of Chief Justice, the dissenting opinion of Justice Harlan 1 in Plessy versus Ferguson became the basis of the unanimous decision of the Supreme Court in Brown versus the Board of Education 60 years later. So that's one of the reasons scholars like to pay attention to dissenting opinions as well. Okay, so back to the point here. If you have at the appellate court level strongly divided, sharply divided opinions on questions of law that are before the court, the Supreme Court may take that case up in some effort to resolve the case. It doesn't mean that the Supreme Court is going to be unanimous in its decision. They may be 5-4 too, or 6-3, or whatever the case. It can be a split decision as well. But at least you have the highest court in the land deciding definitively what the law is on this question. Right? And by the same token, if you have in the appeals process one court overturning another court, then maybe that in sharply divided opinions, that may be a cue that would indicate that the Supreme Court's more likely to review that case. Okay? Next, if there's a civil liberties or civil rights issue that's raised by the dispute. Now that is a cue that is characteristic of the modern court. I'm going to say going back to the 1950s, the 1960s. So for about the last 70 years, let's say, the Supreme Court of the United States seems to be particularly interested in civil liberties cases or civil rights cases. In other words, if they raise questions about the right of free speech or the right of free worship or the right to keep and bear arms or the right to privacy or voting rights or racial discrimination or gender discrimination, it seems that those kinds of cases are more likely to get the court's attention than other kinds of cases. But it may be just a characteristic of the current court. Because we can certainly go back historically before the 1950s, certainly before the 1940s, when it didn't seem that the court was that much interested in civil liberties and civil rights cases. We go back to the 1930s, for example, they seem to be much more interested in cases raising questions about regulation of interstate commerce. Congress's power under the Constitution to do that. We go back to the 19th century, the 1800s, the Supreme Court seemed to be much more interested in cases raising questions of federalism. What was the proper division of powers between the national government and the state governments? So it could be that 20 years from now, I don't know if I'll still be doing this 20 years from now, I hope not. But if I am, maybe I'll have to put some other cue in the place of this one, because maybe the court 20 years from now, it'll be clear that they're not so interested in civil liberties and civil rights cases anymore. Maybe they're interested in some other kinds of cases. Doesn't mean that currently they don't hear other kinds of cases. There are plenty of other kinds of cases. Number 4, if it is a case in which the U.S. government is either a petitioner or respondent, in other words, a party to the litigation. If the United States government is either the petitioner or respondent. Petitioner for what? Think about this for a second. What is the petitioner petitioning for? Angie, you got an adverse ruling at the previous court and you filed an appeal. Right? The court agreed to hear your case. You are the petitioner. You're petitioning for a writ of certiorari. You're petitioning the court to review your case. If the other party, so let's say it's the state of Texas, got a favorable ruling in the lower court, why would they petition for review? Right? They won at the lower level. Right? So they're the respondent in this case. Garcia versus Texas. They're the respondent. Lawrence and Garner versus Texas. Lawrence and Garner were petitioning the Supreme Court to review their case. That must mean that the Texas Court of Criminal Appeals issued an adverse ruling, right? Okay? So, to them. So, Texas is responding to that. So, the petitioner is always going to be listed first. if it's the United States government, U.S. versus Nixon, that I told you about a few minutes ago, the United States Congress asking the Supreme Court. Well, that was a case of original jurisdiction. Let me retract that one, okay? Maybe a case that we haven't talked about here. Well, we dealt with it in the topic on federalism that you had to sort of play catch up on. Missouri versus Holland. That was the case, if you can remember, where the state of Missouri had petitioned the court to declare, or to, there was a federal law that prohibited the hunting of migratory geese at certain times of the year, right? And the state of Missouri was challenging Congress's authority to enact that law. And Missouri is the petitioner. Holland was the federal game warden. Sometimes we don't know just from the name of the case that it's the United States government, but in this particular example, Holland is a person's name. He happens to be the federal game warden that was enforcing the act within the state of Missouri, and so he's the agent of the United States government. So it's really Missouri versus the United States government. All right, despite what I told you a moment ago when we were up here talking about number 3, I said that in the 19th century, the Supreme Court was primarily interested in cases raising issues of federalism. I didn't mean to suggest to you at all that the court's not currently interested in cases raising issues of federalism. So what do I mean by an issue of federalism? If it's a question about the proper division of powers between the national government and the states, or maybe the national government and local governments, there's more of a chance that the court's going to review that case. Okay, so depending on the scholarship that we're looking at, the study that we're looking at, there may be some other cues that are relevant as well. I think some authors have identified other cues, but these are among the most common cues that are identified by those scholars who are arguing Q theory, okay? Now, not terribly long ago, it's probably been a decade or so ago, I was looking at a study that concluded that if none of these cues are present, if you have a case where a writ of certiorari is filed for, petitioned for, and none of these cues are present, there's only about a 7% chance that the court's going to review the case. You would not take your umbrella if the weather forecaster said 7% chance. Wait a minute, did you say 70 or 7? 7. Oh, I'm not taking my umbrella today. Not a very good chance it's going to rain. Not a good chance that the court's going to review the case. But if at least 3 of those cues are present, the probability jumps to 80%. If at least 3 of those atmospheric variables, to extend the metaphor, are correct, I'll stop it with the weather metaphor, sorry. If at least 3 of those cues are present, then there's an 80% chance that the court's going to review a case. If it's a case that raises a civil liberties issue, for example, if it's a case where there were sharply divided or differing opinions expressed by the justices on the court immediately below, if it also raises a question of federalism, perhaps, like, say, just a quick show of hands, how many of you remember, if you've dealt with the chapter on civil liberties and the material that I presented for you on civil liberties in the topic on the right of free worship, do you remember the case Flores, City of Bernie versus Flores? Remember that case? I have one person shaking their head, okay?
I don't remember the details.
Oh, no, I'm not going to put you on the spot and ask you to tell us the details. All I really want to say here is, for the rest of you, when you go back and deal with that week 5 material, if you plan to do that, you may plan not to do it, but if you plan to do that, you're going to come across a case called City of Bernie, that's Bernie, Texas, versus Flores, the Archbishop of San Antonio, the Catholic Church. And it was a case that raised a religious free exercise issue, so a civil liberties issue, and it also raised a question of federalism. So that can happen, right? All right, so the more variables that are present in, indicating rain, the more likely it is that it's going to rain. Same logic behind this theory. That's why I said it's a more empirically satisfying theory than the others. Okay, let's quickly get back on track here. We're going to run out of time here. We're not going to be able to develop this in great detail, but I at least want to get the two criteria out there for you. Okay, so we're backing all the way up now because we started by saying that you've got to have some objective criteria to determine whether City of Bernie versus Flores is an example of judicial policymaking, or whether Griswold versus Connecticut is an example of judicial policymaking, or any of the other cases that we might talk about in this course or in any other context. Is it an example of judicial policymaking? Well, there are two criteria that we're going to establish here. The first is the impact criterion, and the second is the compliance criterion. Okay, so very quickly, the impact criterion says that the court's decision, we've gotten the Supreme Court to review the case, all right? The court is going to now take its vote on the merits of the case. If that decision, we have to take that decision as given. We can't speculate on how it might be different had the court decided the case differently. Okay? We're going to take the court's decision as given and asks, does it have the potential to substantially change or alter an existing policy or practice? If it does have the potential to substantially change an existing policy or practice, it satisfies the impact criterion. If it does not have the potential to change anything, it does not have policy impact, so we could stop our analysis right there and say this is not an example of judicial policymaking. Let me give you an example. Recall Plessy versus Ferguson. We're going to talk about in some detail next week. Okay? Plessy versus Ferguson, I told you, involved a black man in Louisiana who violated Louisiana law by sitting on a railroad car that was reserved for white passengers. The law of the state of Louisiana was separate railroad cars for whites and blacks. And he challenged that. He was convicted, given a prison sentence and a fine for that egregious act, for violating Louisiana law. And he appealed on the grounds that the Louisiana law was unconstitutional. We'll find out on what provision of the Constitution is relevant next time. But he argued that the law was unconstitutional, and the United States Supreme Court said, no, it's not. It's not unconstitutional. So they gave sanction, legal sanction, constitutional sanction to that doctrine of separate but equal. Does that have the potential to, does that decision have the potential to change what the state of Louisiana and other states who may have been practicing racial segregation, does it have the potential to change what they were doing? You got to take the decision as given. Don't speculate about, but if the court had said it isn't constitutional, then it would have been different, right? They said it is constitutional. Look, Louisiana's going to keep doing what it was doing. Right? It's not going to can't change anything. It doesn't have the potential to change anything because Louisiana is going to keep practicing. In fact, for another 80 years or 70 years, is going to continue practicing racial segregation. You see what I'm saying? There's no potential there really to change the course decision. But on the other hand, Brown versus the Board of Education, when the Supreme Court said the practice of segregating white and black school children on the basis of race is a violation of the Constitution, you can't do that. Does that have the potential to change anything? You bet. That one does have policy impact. Plessy versus Ferguson, no policy impact, can't be an example of judicial policy making. Brown versus the Board of Education, it has policy impact, so we haven't talked about the second criterion yet, so maybe. We're not there yet. That makes sense? All right, so once we've determined whether or not there is the potential to substantially change or alter the existing policy or practice, then the next question in our analysis is, what is the extent to which the affected parties actually alter their behavior in accordance with the Supreme Court's decision? You see, the 9 justices of the Supreme Court can't fan out across the country and implement their own orders So when they, in Brown versus the Board of Education, when they ordered that public schools be racially integrated, it's not like they could do it themselves. It's going to depend on whether or not the states and the local school districts are actually willing to comply with the court's order. All right? On that point, since we're talking about Plessy versus Ferguson, if I can get to it here. Here's a little graphic that you may find interesting. When was the court's original decision in Plessy versus Ferguson? Does anybody remember? I told you the date last time. You don't have to give me just give me the year. Who remembers? Did I say Plessy? I'm sorry, I meant Brown versus the Board of Education. 1954, good. May 17, 1954, okay? Second hearing of the case the following year, 1955, okay? So if you look at this, let's just start here. 10 years after the Supreme Court's decision, a decade after the Supreme Court's decision in Brown versus the Board of Education, you had in the South, let's just look at how this worked in the South, okay? You had 98% of African-American school children attending public elementary or secondary schools in the South where the enrollment was 99 to 100% black. Would you say that a decade after the court's decision, when the Supreme Court said in Brown versus the Board of Education that public elementary and secondary schools must be racially integrated with all deliberate speed, would you say that there was compliance with the Supreme Court's decision a decade later? 12 years after the fact, you still have 83% of African-American school children in the South attending overwhelmingly schools that are overwhelming black enrollment. You only begin to see any kind of changes in the numbers beginning in the late 1960s. You get a little bit more of a breakdown, but if you add these two numbers together right here, you still have well over 3/4 of African-American school children in the South that are attending predominantly black schools. And this table ends in the mid-1970s I took it from this source here. That's why, one reason it ends there. There's another reason as well, but you can see that even by the mid-1970s, you had 6 out of 10 African-American school children attending predominantly black schools. So some people would say that over 2 decades after the court's original decision, you still didn't have any meaningful compliance with Brown versus. So I think we'd have to put a big question mark by Brown versus the Board of Education when it comes to that second criterion, right? Was there compliance? Some civil rights activists argue that to this day you don't have full compliance with the court's decision in Brown. So, if that's true, then we might be reluctant to say that Brown is an example of judicial policymaking. Tell you what we'll do at the beginning of the class session on Tuesday. We'll return to the list. Just to finish off this topic, we'll return to that list of cases that we started with, and we'll kind of do a little check just to make sure everybody kind of has that notion, these two criteria down. Okay? All right. We'll see you on Tuesday.